We are going to be doing a lecture on civil liberties from the perspective of AP government. We do have a hook in the classwork packet, but because of time, we're going to go ahead and transition straight to the lecture. So while I'm getting myself set up with my screen, make sure you have those pieces of paper or that Google Doc ready for yourself to take notes. Wow, we are not doing that oral drill. We do not have that time. Yes, today we are going to be looking at civil rights, specifically from the perspective of AP government. Please chat at 100 when you are all set and ready to take notes. Thank you, Isis, Ariana, Emmanuel. Awesome, looks like about half of us are there. Awesome, it looks like most of us are ready, so we'll go ahead and get started. So first, we are going to look at this overview of our Reconstruction amendments and the transition of how equal rights have pertained over time. As we know, the 14th Amendment was ratified with the Equal Protection Clause. Sorry, guys, this is my introduction, so it's not the part I've scripted as well. So these are the Reconstruction Amendments. We know the 13th Amendment abolishes slavery. The 14th Amendment provides equal protection to all citizens. We'll debate that at a later date. And the 15th Amendment ensures male suffrage regardless of race. And as we've discussed in this class, the 14th Amendment has slowly grown in terms of what do we think equal protection counts as. Is it equal protection under the law? Is it equal protection including socially? The Equal Protection Clause is very vague in a way that is very helpful for people that want to utilize it in order to mainstream social progress, but it's also not as helpful because some people try to manipulate what the 14th Amendment stands for. And one period where we see the Equal Protection Clause really grow is during the Civil Rights Movement of the 1860s. And so first, let's look at what this segregated society looked like. As I know, you guys had a great American history teacher last year, so this should all be just review. So Jim Crow society was officially put in place in 1896 under Plessy versus Ferguson, which is the Supreme Court case that declares separate but equal, and that races could be separated legally as long as they were provided, quote unquote, equal opportunities. And this is what officially starts the Jim Crow era. Despite this claim that Black schools were equal to white schools, we know that is not the case. And many Black schools frequently lacked almost any basic necessity that they would need in order to be successful. For example, in South Carolina, Black children attended schools without running water, without usable toilets, and often without electricity. And just to add some monetary explanation to this, in one county, $150 was spent on every white student and only $43 on every Black student. And this is not just the case in the South. In Delaware, which we know is not that far from here, Black students were forced to attend poorly equipped one-room schoolhouses, while white schools nearby were fully equipped. And it is the condition of these schools that raises awareness about what Jim Crow is and what the effect of Jim Crow was on individual citizens. And while, as we know, segregation mostly pertained to the South, it did spread north, which we are going to look at on the next slide. I'll give you 15 seconds to finish your notes on this one. So looking at this map, that's the word. As we see in maroon, these are all states that were required to segregate based off of education. In white, the white states, there are no laws discussing segregation in schools. In red, these are schools where it was optional. And in this like corally pink color, that is where segregation based in schools was forbidden. Take 30 seconds in the Zoom chat. What do you notice? Does anything surprise you? So 1 minute in the Zoom chat. What do you notice or what surprises you? Thank you, Kezia, for starting us off. You don't need to take notes specifically on which states are here. We're just observing what this map looks like. Thank you, Jade. Thank you, Aaron. Erica, would you mind unmuting and elaborating on what you shared in the chat?
I thought that segregation was just something that the South did just because it was an option. I didn't think that it was enforced like that and required to be segregated. That's so corny.
Yes, the idea that segregation wasn't just a thing that counties or cities could opt into, but that they were legally required to practice segregation is absolutely important, because that explains why, in terms of AP government, why so many civil rights activists used the law as a way to help progress forward. We're now going to start looking at, I can get my slide to change. So first, we're going to start with the most important court case in this era, Brown versus Board, which you guys know a lot about. So, as we know, in terms of Brown versus Board, a third grader named Linda Brown was required to attend her school for Black children in her hometown. In order to get to this school, she had to walk 6 blocks, crossing dangerous railroad tracks, and then getting on a bus to take her to this school. However, only 7 blocks in the other direction was a school that was required to be fully white. So she had this very treacherous journey to get to her all-Black school that she was required to go to, when in reality, she had a fully accessible school in her neighborhood that was required to be white. Her father asked NAACP Chief Counsel Thurgood Marshall to sue the Topeka School District. So again, the key name there is Thurgood Marshall, who is played by the late, great Chadwick Boseman in a very good movie. Distracting. The case was filed in 1951 by NAACP's lawyers, but it did not get to the Supreme Court until 1954. And what's important to know is that Brown versus Board of Education is actually 1 of 5 court cases that had been combined to be brought before the Supreme Court. So this is what we know of. This is the one that we are the most familiar with, but there are several other court cases that were used to argue for desegregation of schools. And as we know, the ruling of this court case is that under the 14th Amendment, separate but equal educational facilities are inherently unequal. Now let's zoom in on the work of Thurgood Marshall, because his work did not stop with Brown versus Board. Marshall, along with other NAACP counselors, lawyers, had been working for years to end segregation. Brown versus Board would just happen to be the most popular and the most successful court case that they argued. For example, in 1950, Thurgood Marshall participated in Sweat versus Painter, where the court ruled that a Texas law school that had been claiming to give Black students access to education equally were not doing that. And this is a higher education school. And Thurgood Marshall and his colleagues succeeded. They proved in this higher education setting that there really was not a separate but equal practice when it came to their Black and white students. However, as we know, higher education is something that technically people opt into. So this was not the best case to end segregation holistically, because these are technically private institutions. So that is when they find Linda Brown and this court case of Brown versus Board. And because this is a public school that all children are able to opt in, it is all children have the civil right to an education, which is why this court case was chosen by Thurgood Marshall and his colleagues as a way to argue for desegregation. In that court case, something that Thurgood Marshall did that was a little bit different was he used the expertise of psychologists, specifically Kenneth and Mamie Clark. And the work of Kenneth and Mamie Clark helps prove the true detriment that segregation was having specifically on Black children. And what they argued is that these separate but quote unquote equal schools were damaging Black children's self-esteem, stigmatizing them, and this was affecting their self-image for the rest of their lives. And what this shows is that school segregation reinforces this idea of difference and inequality, which is associated with racism. Give you 15 seconds to finish jotting that down. I know that was a lot. Now we're going to look at the bigger impacts of Brown versus Board. As we know, Brown versus Board overturns Plessy versus Ferguson. So again, the court agrees that under the 14th Amendment's Equal Protection Clause, segregation was unconstitutional. But what this specifically does is, because education is considered a civil right, they argue that segregation is unconstitutional in the realms of education, things that people have a civil right to do or a civil right to have. So now the question begins, how far does desegregation go? The court's ruling only applied to public schools. And what this shows is that the separation of Black and white Americans signaled the inherently unequal status between them. And so now that they have public schools desegregated, it was time to desegregate with deliberate speed. In the summer of 1955, the Supreme Court issued its implementation ruling in the decision called Brown 2. In Brown 2, the court ordered that schools undertake desegregation with all deliberate speed. But what came under dispute is, what is deliberate speed? Is deliberate speed immediate? Is it within the next 5 years? Is it within the next 10 years? And this is what was speculated on by the Southern resistance to this, the white Southern resistance. And white citizens in the South organized their massive resistance campaign as a way to fight and a way to undermine desegregation. And while we know Brown versus Board did a lot of good, it also set up change, a lot of different change. And as we know from last year, Brown versus Board is simply the beginning of the civil rights movement. One of the major milestones in the civil rights movement is Martin Luther King Jr.'s letter from Birmingham jail. The letter from Birmingham jail, if you just want to put a star next to this slide, this is one of the required foundational documents that you will be expected to know for the AP exam. And we're going to be doing a deep dive of this document on Thursday, which you should have seen the pre-work posted last night for you to get started on. The pre-work should only take about 15 minutes. And again, we're going to zoom in on this letter on Thursday. The purpose of the letter from Birmingham jail was for King to address the criticisms of the civil rights movements. And he argued specifically against the white clergymen who did not support desegregation and did not support the civil rights movement. He argued that the teachings of Jesus showed that nonviolent activities are intentional and they should be permitted and encouraged. And his letter from Birmingham jail sets up a wave of new legislation to encourage African-American civil rights, or the implementation and protection of African-American civil rights. The Civil Rights Act, Voting Rights Act, and Housing Rights Act are all three laws signed by President Lyndon B. Johnson, or LBJ. The Civil Rights Act of 1964 outlawed discrimination against voting, and stimulated employment opportunities. The Voting Rights Act of 1965 outlawed poll taxes. And the outlawing of poll taxes is also the 24th Amendment. 24. And the Voting Rights Act of 1965 is a reaction to those limiting access to voting, the access to voting of African Americans. And finally, the Housing Rights Act of 1968 banned discrimination in housing applications. So it's equal opportunity housing. Thanks, guys. I know it's a hefty lecture, only 3 more slides. Now we're going to transition slightly from the African American civil rights movement to the women's movement. On the screen, you can see a timeline of the women's rights movement. As we remember from APUSH, the Seneca Falls Convention of 1848 was this initial push for women's equality that would take years to get some fruitful benefits out of. Women's suffrage was guaranteed in 1920 with the 19th Amendment. So the 19th Amendment is in 1920 and guarantees women's right to vote. So again, women's suffrage is approved in 1920 with the 19th Amendment, so women now have the right to vote. Feminists then create the NOW party, the National, nope, I always forget what NOW stands for. National Organization for Women, that's what it is. So the feminists, after the 19th Amendment was passed, created the National Organization for Women as a way to help guarantee continued improvement in women's civil rights. One thing that they involved themselves on was the Equal Pay Act. After the Equal Pay Act was drafted after the Civil Rights Act of 1964 as a way to help capitalize on this continued improvement of civil rights. The next major piece of legislation is Title IX, which allows women equal opportunity in the participation in sports and college. Yes, Erica.
Sorry. The Equal Pay Act was just something they promoted right now, something that actually happened.
Oh no, it did not happen. Yes, equal pay is still a thing that we're working on. So Title IX allows women equal opportunity in participation in sports and college. So what this means is that college admissions cannot prioritize a male application over a female application. As we know, Roe versus Wade in 1972 legalizes a woman's right to choose an abortion if that is the correct path for her. Under the right to privacy. And the next piece of legislation that many women are continuing to fight for is the Equal Rights Amendment. The Equal Rights Amendment has not been ratified. It has not been passed. But the goal of the Equal Rights Amendment is to be basically the female equivalent of the 14th Amendment, where the 14th Amendment very specifically says all men are entitled to equal protection, X, Y, and Z. The Equal Rights Amendment is an amendment that feminists have been fighting for since the 1970s to guarantee all rights, regardless of sex or gender identity. Two more slides, so we're going to try to go through these really quickly so that we have all the information for the next for the rest of the week. Another group that has continuously fought for equality is the LGBTQIA+ community. And so these are some really important laws that have been passed in order to help advance the equality of these people. In 1973, a major stepping stone was made that shouldn't have been a stepping stone. In 1973, homosexuality was removed as a mental disorder from the psychiatric community. So before 1973, if you identified as part of the LGBTQIA community, you would have been labeled as having a mental disorder for that. In 2003, Lawrence versus Texas. Oops. Oh, come on. Sorry, I missed this in my notes, so I'm just double checking Lawrence v. Texas. Lawrence versus Texas is officially the court case that argues that condemning or punishing for homosexual acts was unconstitutional. So before this, in some states, if you were caught performing your sexuality, you could have been imprisoned or punished with a fine for it. And Lawrence versus Texas is what argues that that is unconstitutional. In 2010, President Obama overturned Don't Ask, Don't Tell, which is a policy that was enforced in the military. If you were part of the LGBT plus community and if you were part of that community and in the military, it was argued, do not ask, do not tell. So you were forced to go back into the closet if you were in the military. Unfortunately, there was a step back with DOMA, or the Defense of Marriage Act. And what the 1996 Defense of Marriage Act argues is that if somebody gets if a gay couple got married in Vermont, which was the first state to legalize homosexual marriage, if that couple had to move to another state, their marriage would not be recognized by that state. So if you were forced to move for whatever reason, you would no longer be legally married and entitled to those benefits, even if you were married in a state that legalized it. And finally, there was the major step forward in Obergefell, I always mispronounce this name, versus Hodges, which legalizes same-sex marriage and argues that that is a constitutional right under the Equal Protection Act. However, as we know, we are continuing to have this debate over religious refusal to acknowledge these rights, and also this has continued to expand as we work on fighting for transgender rights as well. So those are some successes that we've had with the LGBTQ plus community. However, it is still continuing to be a step forward. Okay, we're gonna pause there because we do have one more slide, but I will wait until our lesson on affirmative action to do it, so that way we have enough time for our exit ticket. If you have any questions on the lecture, feel free to private chat me and I will respond. But you can go ahead and transition to the exit ticket. It is only 3 multiple choice questions. And once you submit your exit ticket, you will be free to go. Again, if you have any questions, feel free to chat me.